Rob Whitman is our session moderator. Fantastic lawyer from Safe Earth Shore. I interviewed him a long, long time ago when I was at K.O. Gordon, and we made him an offer, but he turned us down. I don't mind it. I get endeared to people who've turned me down. Rob is a very fine labor and employment lawyer at Safe Earth Shore and a member of our advisory board, very active in pro bono matters for his firm.
Well, thank you, Sam. I should just sit down after that lovely introduction. I'm the morning session moderator, which is really a glorified way of saying timekeeper. So I will try to keep these great panelists on schedule, but I'm sure it will be a vigorous discussion nonetheless. So we have two sessions in our morning program, but the first session consists of three panels. So make sure you kind of stay focused on that. So our first, the overall title is Employment Law Reform for the Long Haul. As we know, Sam does not want us to be short-term thinkers, so we are here thinking about long-term, long-haul reform of employment law. The first session is on employee data privacy. We will have a series of speakers and commentators in keeping with the NYU tradition. The speaker will be Professor Matthew Bodie of the University of Minnesota, who I understand will be on Zoom at some point soon. And our commentator will be Dan Murphy, who's the Deputy GC and Senior Vice President of Labor Relations at Verizon. Our second session will be on pregnancy and related work protections in the wake of the Dobbs decision. We're nearing the one-year anniversary of that momentous ruling, so there will certainly be plenty to say on that. Our speaker is Kate Muting of Sanford Heisler Sharp, and the commentator is Holly Weiss of HWH Mediation. And then our third session is on employment law reform, rethinking employment contract law. Sam will be presenting along with Professor Rachel Arno Richmond, the University of Florida, and the commentator will be Doug Schwartz of Morgan Lewis. So I will leave it to them and be back to make sure they stay on schedule.
Who goes first, Rob?
All right. Can people hear me?
Yeah. We don't ordinarily, Matt is a special person, by the way. Matt is also a graduate of NYU, co-author of mine, and he's now at the University of Minnesota School of Law. And Matt has COVID. That's one reason we don't usually allow audio participation unless you are God. All right, Matthew, it's all yours.
Since the presentation's about privacy, I may have a claim against Sam there, but no. I think it's good to reveal that I am. It's best for me and for you that I am not present, and I'm really sorry to miss it. I know it's not only something that I really enjoy coming to every year as a staple. It's something that brought me into the legal academy when I was at the NLRB. Back in the late 90s, and this is a special one, right? The 75th annual. So I'm grateful to be able to present to you, and I'm very sorry not to be there under the circumstances. All right, I'm going to share my screen so that you can look at something other than my camera. Hopefully everybody can see this. Let me know if there's any issues. So my presentation today will be on employee privacy law, past, present, and then I'll talk about three possible futures. Just a brief word on the past. I know a lot of you are familiar with this, but obviously surveillance of employees goes back to the employment relationship, right? The employment relationship is founded on the right to control. In order to control, you need observation, you need monitoring, and Taylorism was, obviously one of the first well-known instances of trying to bring a method, a comprehensive approach to that monitoring to try and scientifically manage the production process. There have been protections for employee privacy ever since the privacy torts existed arguably since the Warren and Brandeis article in the late 1800s, but it was Dean Prosser who instantiated them in the restatement of employment or the restatement of torts, second. And things like intrusion upon seclusion and private disclosure of public fact have been brought by employees against employers in a variety of contexts for some time. The California constitutional protections under Article 1 apply to private individuals, unlike the U.S. constitutional provisions. So that also has been a source of protection for employees for some time. A recent decision in Hernandez versus Hillside said it was very similar to the tort protection. Fair Credit Reporting Act obviously has taken on a life of its own now that consumer reporting agencies are much more broadly defined and more active on the web, but that has been around since 1970. There were some computer-oriented protections in the 1980s, and some of you may be familiar with cases like Conop versus Hawaiian Airlines, Deal versus Spears, where employees were recorded or taped, or in the Conop case, there was an early website that was protected. The employer snuck onto there using credentials of another person. There has also been protections like the Employee Polygraph Protection Act, designed to protect employee privacy. After that, starting in the 90s, we saw kind of a second generation with the Americans with Disabilities Act, protections against inquiries or examinations that may reveal disabilities. The Genetic Information Non-Discrimination Act has also taken on a life of its own as a privacy statute. It was intended primarily to prevent discrimination, as the title shows, but it has stepped in as a way of preventing employers from collecting this information. There are some state drug testing statutes and some common law decisions that have applied to state drug testing. And then the most recent wave has been state protections against employers requiring employees to hand over their login information, including password, about their social media accounts. A number of states have those, at least 30 at this point. All right, so this revolution, though, that we're talking about today, it's not that recent, right? I like to point to this Business Week cover from 2008 as a way of covering exactly, covering all this data-rich environment where employees are looked at from a variety of contexts. So it's been around for a while. But in terms of the present, right, some things that are coming across the culture in terms of fear about what employers are doing is this idea of pervasive surveillance, right? I think the Amazon warehouse is probably the example A of this. Also, invasive analytics. This is the creepiness factor that you often hear about with regard to privacy, right? What sort of creepy and now potentially dangerous to individual health types of analytics are out there that can be used by employers even without the knowledge of employees. I think there are a few things that are creating this environment, and I have a longer paper that came out last year in the Indiana Law Journal that I'd be happy to share with people. Oh, and by the way, if anyone wants a copy of these slides too, I'd be happy to share them with you. Just shoot me an email. This eroding barrier between business and personal, obviously the pandemic, as I speak to you from my home, is one example of that. The personal data that is shoveled into AI and algorithms, and that I may be at present at work, but a lot of it is personal data to me. And also social media accounts has blurred that line as well. Employees, in some ways the firm has taken on more weight as capital intensive industries in manufacturing are replaced with information intensive industries that use data. And the more data employees contribute to their employer, the more they become locked in because that data, that history of work that they provided is useful and in some cases essential to the ongoing business. So obviously Uber and Lyft and other platform employers generate data about their employees, use that data, and in the cases of the platform ride-sharing companies, do not share the long-term benefits of that generation, including and up to possibly self-driving cars, right? All this data might be used to facilitate self-driving cars, and yet putting workers out of work. But that data is all generated by the drivers themselves. On the other end of the spectrum, you have professional athletes who, in some cases, do feel exploited, right? Athletes are often monitored in their sleep, for sleep patterns. Every aspect of their biochemistry is often dissected, both to detect drugs, illegal drugs, but also to detect, are your metabolites at the right level? Are your electrolytes, maximized? You can tell I'm not a doctor. So those workers, in some cases, want the analytics, right? Because they want to improve their performance. They want to be the best athlete they can be. And the question is, how is that data managed, right? How is that data managed? So just to run through very quickly a number of recent developments in the privacy space here. Consumer privacy statutes are the big movement here in privacy law. And just recently, the California statutes have applied in the employment context, right? There was some debate. There was a holding pattern for a while where employee data was not covered by these statutes. There was an effort to pass some legislation, but nothing passed specific to employees. And now we have this environment where, to the extent the employees can be treated as consumers, and the definition of consumer under the statute is very broad. Anytime employees' private information, personal information, and sensitive information is subject to use and processing by the employer, there should be notice and consent. There are also additional rights that employees have that have yet to be fully worked out, but the rights under these statutes include the right to delete information about yourself, the right to correct information about yourself, opt-outs of third-party resales. One ongoing question I have is, to what extent are employers selling employee data to third parties? I have not heard of this as a widespread phenomenon, but I don't want to be naive either, so I'm very curious about that. There are a new wave of these consumer privacy statutes, but Virginia and Colorado, thus far, have exempted employees from inclusion. We'll see if other states pass these laws, if these laws include employees or not. Specific to warehouses, California started the trend, but New York and Washington have also passed legislation regarding productivity metrics in warehouses. The idea here is to make employers tell employees exactly how they're being judged, and to make sure that the algorithms themselves don't push workers past their breaking point, don't violate health and safety protocols, do not make sure that rest breaks that are often required under law are in fact incorporated into the algorithm. And in some cases, if employees are punished, have anti-retaliation protections for those actions. Biometric data protection, the Illinois BIPA, obviously making big waves in this area, a number of very multi-million-dollar settlements or judgments, including involving employees. The specific rights here are notice and written consent to use the data. The data has to be used along with the purpose that it was generated for. There has to be a plan to destroy the data, and a prohibition on third-party sales. There's a private right of action here. It's different than the California statute in the consumer context, for example. There's no need to show harm, which is often a big issue in privacy law with regard to standing, particularly in federal court. In Illinois state court, there's no need to show harm. The federal courts have been mixed on that in the BIPA context. Recently, as Sam has written about in the New York Law Journal, there is preemption in the context of a collective bargaining relationship. The court said that in order to determine whether these rights are being violated, we have to interpret the collective bargaining agreement, and that means that it's preempted under Section 301. All right, so I believe there was a panel on this last session yesterday, so I will not spend time on this too much other than to say this is another area that is hot, that there's a lot of contemplation of statutes. New York City has led the way here. Questions about what exactly is an automated employment decision tool, what sorts of testing and auditing have to be conducted in order to make sure that there's no discriminatory bias, under what circumstances for reasonable accommodation purposes should there be an alternative selection process. A lot still up in the air. It keeps getting pushed back. I believe it's July 5th now is when it's set to go into place. But all right, so that's kind of a brief overview of the present. And I wanted to lay out 3 possible futures before handing things off to my terrific commentator, Dan Murphy. The first is kind of status quo, but going forward, right? Which would be this expanding, continuing patchwork of applications. So you can see that the state consumer privacy statutes are becoming more popular. I can certainly see, I believe Tennessee has just passed one or is considering one. We could just see those, spreading from 10 to 20 to 30 and onward states. The question is, right now, it's primarily, particularly in these consumer statutes, a notice and consent approach. We might also see more subject area statutes with regard to fear of identity theft. That's a lot of what the consumer statutes are driven by. Biometrics, machine learning, and automated tools, and also regulations specific to certain contexts, such as the warehouse cases. The big questions out there, if this is the status quo, if this is the future heading forward, will there be a federal data privacy statute? There seems there's hope springs eternal, but nothing on the radar right now that I think is expected to be passed. And then, obviously, as we've heard from our government officials at this terrific conference, there is action being taken by various agencies within the federal government. Of course, state agencies are looking at this too, in terms of preventing discriminatory algorithms, preventing violations of health and safety, regulations through algorithms, things like that. All right, another future would be one that's based more on the GDPR, the EU's 2018. I believe yesterday might have been the 5th anniversary of the GDPR going into effect. So we're somewhat timely. Transparency, some of the rights under the GDPR, you might, one of the points I want to make in my presentation is that a lot of these things that the GDPR sets out as kind of a model framework are being echoed elsewhere in state privacy law and federal approaches to privacy law. So idea of transparency and notice, access, correction, erasure, restrictions on the ability to process and use under certain circumstances, a limited purpose for data collection, right? If you collect it for one reason, you can't then use the data for a variety of other reasons. Also data portability, right? Can I take my data and take it to another platform? Can I take it to another employer, right? Under the GDPR, that is one of the rights that's afforded to data subjects. There's a GDPR mindset that I think that is very different than traditional American approaches to privacy, which is that instead of American privacy checks to see if the collection is okay, GDPR says, no, it's not just when you collect it, it's you have to use it for proper reasons. You can't use it for a variety of reasons. That information is not yours to use as you want once you collect it. Consent is not efficient in the employment context. The idea is that the employee is under such a oppressive relationship that there are so many factors that are way against employee free choice when it comes to data use within the context of employment that the employer essentially has to come up with a legitimate business interest that would outweigh the employee's data rights in order to use the data. And then there are some other exceptions for public compliance and things like that, but that's the primary driver higher standard for sensitive data, and Article 22 of the GDPR, which allows for choice as to automated processing. The GDPR is very popular in certain circles, but it is not very popular, I would say, with the Chamber of Commerce, for example. And so I think whether it takes off here in the United States as yet to be determined. There are a lot of trade-offs, and I think that's something that my commentator is going to talk about a little bit as well in terms of innovation and flexibility. And then, of course, is it a federal statute that takes the approach of the GDPR, or is it just state statutes? What would be the enforcement mechanism? All right. Finally, I just want to end on collective power as a possibility for our future of data management in the employment context. There are a lot of questions out there, and again, my paper that came out last year talks about not just privacy but property. The employers take all this data and they turn it into a trade secret, right? And that's why obviously there's so much of a need to protect this, because that's part of the law, right? In order to have a trade secret, you have to keep it protected. But employers are looking at this as a value proposition. And I think part of what employee advocates have to think about is, to what extent might a privacy invasion be justifiable if the employees are not taken advantage of with that data going forward? If they have some sort of rights in the data that would allow them to protect themselves, beyond just kind of drawing the curtain down and saying you can't take the data in the first place. Individual versus collective, I believe obviously that one's individual data is very meaningful to an individual person, but it might not be that important, and that really the power here is collective rather than individual. And this question of notice and consent, which has been the traditional modus operandi of privacy law in the United States, should give way to control, right? The ability to have ongoing control over the use and disclosure of your data. So I think there's some really interesting questions about to what extent union representation is the answer here. There's in the ongoing Writers Guild strike, obviously the use of AI has been getting a lot of attention. Some question about whether that's a mandatory or permissive bargaining term. I think you're going to see more bargaining here in this space. I think if it comes to something like an automated decision tool that is promoting or demoting employees, obviously that is a mandatory subject, I would think. But there are going to be other areas like shifting some projects to AI, potentially some writing projects to AI that employers are thinking about, the studios are thinking about, that might not be mandatory, but there might be real grounds for give and take negotiation on that. And also just in terms of this privacy versus property dichotomy, bargaining for privacy versus bargaining for a share of the pie. The potential for data councils, sectoral data bargaining, right? That's something that could be pursued. But at the same time, right, since privacy is an individual matter, we would want to make sure we respect individual protections and consider some sort of Bill of Rights for employees as a whole. Right. So that's my presentation, and I thanks again to Allison and Sam for facilitating this, and I look forward to your questions and comments.
Thanks, Matt. So I'm going to pick up kind of where Matt left off and focus really on how we see the issues Matt talked about showing up in collective bargaining, to what extent we see them showing up in the future, and maybe comment a little bit about how GDPR as a potential solve in this area. I should say at the outset, despite the red Verizon check mark on my vest, any opinions expressed here are my own and not my employer's. Everybody can feel free to thank me for their great Verizon service separately. I'm not accepting complaints about your Verizon bill. So,
Customer service.
I think as we've heard the discussions about this yesterday and today, this whole topic of AI and its effect on the employer-employee relationship, it's so multifaceted. And I think some of those facets are ones that employers and unions are very accustomed to dealing with in the collective bargaining context. So there's an aspect of this that, that smacks of monitoring. And there's obviously robust body of law at the board regarding what employer monitoring can look like and not look like and chilling Section 7 rights. I think there's also a lot of history of employers and unions negotiating over particular technological developments that facilitate monitoring. So think collective bargaining agreements that restrict the use of GPS or bargaining over placement of covert or overt cameras. There's also aspects of this that smack of performance management, and there again, I think employers and unions very well accustomed to bargaining over those things. So to the extent that AI data sets are going to be used to facilitate decision making or even make decision making, it's easy to think about how those bargaining dynamics kind of play out, about bargaining around parameters there. And then there's aspects of this that smack of kind of automation, technology coming in, displacing workers. There again, I think there's a lot of history of that being a typical topic of bargaining. My background was in the newspaper industry, and there was a lot of history there as technology came in to newspaper production, unions bargaining either for job protections or to gain a foothold in jurisdiction in new work that was created as automation came in. The piece that's novel, I think, or the facet that I don't think a lot of labor professionals have grappled with is the one Matt highlighted about the new value that's being created here by taking these very powerful algorithms and allowing them to do human-like decision-making on these tremendous data sets that humans themselves couldn't apply their decision-making to. And the data sets consist not just of business data, but also intermingled are things that we would think of in some regimes as personal data. That's something I don't know that there's really precedent for, and it's not something that, at least I've seen as somebody who watches this space closely, employers and unions have to grapple with until the very timely example that Matt just noted of the Writers Guild strike going on right now, where it does seem like this is emerging as one of the themes, the future use of AI technology by the employers there, and the data sets that are being used to feed that technology are the ones that were created historically and would be created in the future by the striking workers. So if this is such a big deal, how come we haven't seen more of it yet show up in the organized labor context? I think there's a couple of reasons for that. One, notwithstanding the media hype and some of the scare headlines, it does still feel very much to me like early days, and all the displacement applications that we hear tell of all seem like they're future-looking. I've yet to I see the person displaced today by an AI application, so I think there's a little bit of maybe denial and backward-looking going on that'll come more to the fore when these applications are more in deployment. I think the fact that there's been a lot of focus on the bias applications. We heard the discussion yesterday. Matt mentioned the new New York City law aimed at policing bias in that area. That's an area that touches obviously upon collective bargaining concerns, but maybe doesn't go so much to the core of them. And so I think to the extent the focus has been, is the AI decision-making fair or biased? That's something that maybe has not been a core collective bargaining concern as yet. And then I think another interesting dynamic is that the monitoring and privacy aspects of this and the regulatory and legislative efforts we've seen there may actually be in a way kind of functionally preempting some of the kind of collective bargaining energy we might otherwise see. So I'm thinking there, for example, of the warehouse laws that Matt alluded to that have now been passed in California, New York, and Washington State. These laws put certain parameters on how employers can deploy AI to set performance metrics, disclosure requirements, transparency that has to be placed around them. To the extent that those legislative efforts are caring for what might have been some of the worst behaviors and the worst uses of AI, they may actually be draining kind of organizing effort that would otherwise be placed around it, and people may be looking for legislative rather than collective bargaining solves. The same may be true to some extent with regard to some of the privacy solves. Matt mentioned the Illinois BIPA and the Sam's article about the preemption that exists there. Although there's legal preemption for unions to collectively bargain outside the BIPA context, there may be sort of a functional preemption going on where, because BIPA cares for what would otherwise be a lot of the workers' concerns, the energy that you might otherwise see going into collective bargaining is instead being channeled through legislative regulatory efforts. I wanted to touch a little bit on GDPR as a potential solve here for those in the room, especially who are familiar with dealing with employees in Europe. I think it's a interesting framework, but one that I don't think is a perfect fit here. And just to offer a couple observations on that. One, I think going back to Matt's point that the really novel thing here is that we have truly personal data and business data kind of coming together and being put through the same AI processes. That's something that I don't know that GDPR is well set up to address. GDPR really does function on that focus on that personal data. So I don't think it solves, like thinking of examples like the writer's strike. The work that's been created by the writers to this point, we would think of under traditional copyright principles as works made for hire, and that copyright regime is not one that squares easily with a GDPR type notice consent approach to personal private information. Second point I'd make is sort of a distinction here between structured data and unstructured data. When we think about the employment relationship, we've got a wealth of structured data about employees, things that you think of like a traditional personnel file. And it's somewhat easy to think about applying a GDPR-like framework to that kind of data. But there's also a wealth of data that exists in other places that employers are going to have about employees. Think of the things like the daily tools employees are going to use to communicate with each other, whether that's Slack or email. And all of those things are also going to be part of AI applications going forward. So I don't know that a GDPR-like regime is set up well to care for the unstructured nature of that data. And then the last point I make, and before I turn it over to the rest of the panel here, Matt concluded with sort of noting about GDPR, its advance, consent, and limited purpose use of data. And that's where I think there's going to be a fundamental tension with some of the AI applications that you're going to see businesses want to use going forward. I can think of data that employers collect for one purpose, and when they collect it, assume it's only for a limited purpose. A lot of these AI applications that have not yet developed are going to surface purposes that, frankly, people don't know about yet. And in an ex-ante consent regime like GDPR, I think it does have I think there'd be a lot of concern about constraining those future uses and tying them back only to the limited purposes thought of the outset. We can all think of sort of sinister applications of that, where it would be against the interests of the workers. There are probably also many instances where we think of positive uses. To call out just one or two, I think about the data that a lot of well-meaning employers use today to advance their DEI initiatives, or DEIA. I have to care for that piece of my vocabulary. A lot of that data was collected initially for limited purposes, for compliance purposes, but is now being put to all kinds of uses that employers are out there touting as being favorable for their companies, but also for their employees. That's an example using something that's clearly personal data, but where I think future applications, apart from the original collected use, are going to be made. There's also examples with business data, as employers are now sort of managing this whole return to the office post-pandemic and tracking employee usage patterns and the like, trying to use that data in ways large and small to make the worker experience better. And again, I think an ex-ante consent regime and how it would constrain usages like that is something that would potentially impede a lot of positive developments. So I think there's opportunities there, but limitations as well.
All right, thank you. Thank you, Matt and Dan. Now let's turn it over to Kate and Holly for the next topic.
Thank you. Holly and I are going going to talk about pregnancy and related worker protections post-Dobbs. And as you saw in your materials, we've been tasked with thinking through reforms for the long haul and in particular highlighting areas that may attract consensus. I'll say I am an optimist by nature, but even I am finding it difficult to think through areas of consensus post-Dobbs. So we definitely have our work cut out for us today. We're going to talk through three big areas and explore possible consensus within them. The first is employee accommodations, accommodations for pregnant and nursing workers post-Dobbs. The second thing we're going to talk about is anti-discrimination and anti-harassment protections for workers seeking abortions post-Dobbs. And finally, we're going to talk about employers who elect to provide travel benefits for those employees who need to travel in order to obtain abortions. So first, with respect to accommodations, the accommodation piece, this is an easier way to find consensus, easier area to find consensus because we have two laws that have been enacted post-Dobbs where we already have this consensus. So the first is the Pregnant Workers Fairness Act that was signed into law at the end of last year, and it will go into effect next month. It requires employers to provide reasonable accommodations for those workers with known limitations due to pregnancy, childbirth, or related medical conditions, absent and undue hardship. This requires an accommodation even absent a showing that the employer previously has provided this accommodation to those similarly situated in their ability or inability to work. And that fills a gap that was in the Pregnancy Discrimination Act as highlighted by the Young v. UPS Supreme Court decision. Like the ADA, this law requires an interactive process, and it also prohibits retaliation for requesting or using an accommodation. It also requires an accommodation even if the employee is unable to perform the essential functions of her job, provided that the inability or that the limitation is a temporary one and can be reasonably accommodated. The second area of post-Dobbs consensus in this accommodation piece comes from the Pump for Nursing Mothers Act that was also signed into law in December. That went into effect last month. That requires reasonable breaks for employees to express breast milk each time there's a need for up to 1 year. They must be completely relieved of their duties on that break, or they must be paid for that break. Employers must also provide a place to express the breast milk other than a bathroom, and it does create a private right of action for that, filling in a gap that we saw after the Affordable Care Act, where there was this requirement for a place to pump, but there was no private right of action associated with that. There is an undue hardship defense for this, but only for those employers with fewer than 50 employees, and those numbers of employees are calculated regardless of work site. Unless you're an airline flight crew member, in which case you don't have this right to pump at work at all. All employees can also look to FMLA protections, state law protections, which are explicitly not preempted by the Pregnant Workers Fairness Act. So next steps in this area, we do expect the EEOC guidance on the Pregnant Workers Fairness Act to be issued by the end of the year. We will need to interpret and figure out how courts are going to interpret this law. On the other hand, there is a lot of existing body of law already. We already know what it means to be pregnant, childbirth, or related medical condition because of the PDA. We know what an undue hardship is. We know what an interactive process is due to the use of those terms within the ADA.
Very fast, yes. Yeah. So, quick show of hands, how many people knew about these two federal statutes? That's pretty good. A bunch of employment lawyers in New York who prefer federal court. That's what we get. So, great, consensus, but actually what I think is we've opened up the door for divisiveness. Kate just said we already know what pregnancy, childbirth, and related medical condition means. We've litigated that. It includes abortion, at least under Title VII, under the PDA. Will that be relitigated? Let's say it's litigated under this statute, the accommodation statute. I think the case is strong that abortion care is part of pregnancy, childbirth, and related medical conditions. Think about the chronology here. The PWFA was decided after Dobbs, so Congress knew that abortion was no longer or not a constitutional right. So the language that talks about exercising a constitutional right as being protected It's more of a descriptive thing that we'll get into in a little bit. So bottom line, I think employers will be well served to accommodate not only actual pregnancy, but also abortion, abortion care, time off for medical conditions related to abortion.
So in the accommodation space, we already have some consensus. The second topic we're going to talk about is in the anti-discrimination and anti-harassment space. So Title VII prohibits discrimination on the basis of protected characteristics. That includes, under the PDA, pregnancy, childbirth, or related medical condition. And as Holly mentioned, cases that have interpreted this have held that abortion falls within this definition. So you have a couple cases in your materials at the circuit levels. They are holding that abortion is a related medical condition. They're looking at the plain language of the statute. They're looking at the EEOC guidance, which is explicit that abortion is a protected characteristic. And they're holding, as I said, that abortion is a related medical condition. Some are now arguing that in the wake of Dobbs, this should be relitigated and we should revisit this. One of these individuals is NYU student and recent graduate Zachary Garrett, and his paper has recently been accepted for publication, and that abstract is in your materials. So Zachary, and I'm sure others, are arguing that these decisions holding that that abortion is a related medical condition and is protected under Title VII were premised on the fact that abortion is also a constitutional right under the federal Constitution, and now that it is no longer a federally protected constitutional right, we need to re-examine this and whether or not it's a statutory right, statutory protection under Title VII. And a re-examination under the plain language of the statute, he is arguing, and others are arguing, that pregnancy or abortion is not pregnancy, abortion is not childbirth, and abortion is not a medical condition. So I'm not particularly optimistic that we'll have consensus on either side of this. There are several counter arguments, and Holly's going to go through a few of those now.
So I'm glad there's some counter arguments here. First of all, let's talk about the plain text of the Pregnancy Discrimination Act. It prohibits discrimination against workers affected by pregnancy, childbirth, and related medical conditions. I have a keen observation here. You can't have abortion without pregnancy. And that sounds, it was a little chuckle there, but with a little bit of seriousness here, let's think about Bostock, an analogous argument. This is what the Supreme Court said. Discrimination based on homosexuality and transgender status necessarily entails discrimination based on sex. The first cannot happen without the second. All right, so you can't have sexual orientation discrimination without sex discrimination. Likewise, right, discrimination based on abortion necessarily entails discrimination based on pregnancy. The first cannot happen without the second. So that's the counter argument. I would also argue that the student's proposition hangs on the fact that the courts, in rendering their decisions.
If I knew that Zach Garrett, my student's note would be so prominently critiqued, I might have had him on the panel.
I wish he were here. It'd be nice to hear this, but it's a great paper, I should say. It's very thorough and very thought-provoking. I've just been asked to do some counter arguments. So one of the things that the paper hangs on is that the courts described abortion as a constitutional right. So they said, you can't discriminate against a woman who exercises her constitutional right to abortion. In my view, it's just merely a description that was correct at the time, right? No longer post-Dobbs, correct. However, there's nothing in the case law that says that it being a constitutional right is some kind of prerequisite to what is included within the categories of pregnancy, childbirth, and related medical conditions. So that's my 2 cents on that piece.
Yeah, and I expect we'll continue to see arguments on both sides and all sides of this issue. In the meantime, I would also expect some enhanced state law protections and local law protections, explicitly calling out protections on the basis of having an abortion. There are a handful of states and municipalities right now that do explicitly protect against discrimination on the basis of reproductive health choices: New York, DC, California, and a few others. Also, practically speaking, I would say, I think that an employer would have to be very deliberate in teeing up this challenge, and very explicit in desiring to challenge whether abortion is a protected characteristic within Title VII. Otherwise, I think it'd be fairly easy for an employee or employee advocates to make the case that the discrimination and harassment were not occurring because of abortion, but rather because of gender or because of pregnancy, which are clearly protected, because of marital status, which is clearly protected in many jurisdictions, or because, as Holly mentioned earlier, the employee is requesting accommodation to have an abortion within the PWFA, or being retaliated against for requesting or using that accommodation. So to the extent that abortion is not a protected characteristic within our Title VII framework, I think it is a very, very narrow exception to that. In terms of consensus for the long haul, we are seeing, and I know there's a lot of management side advisors in the room who can probably speak more to this, but in the client alerts that we're seeing post-jobs, we are seeing a lot of employers being advised not to discriminate on the basis of having an abortion. So I think in the short term, we're seeing consensus form around that. And then the third kind of big picture topic we want to touch on is employer-provided benefits for abortion travel. So we saw in the immediate aftermath of jobs many employers coming out very publicly and saying, we will pay for our employees to travel if travel is necessary in order to obtain an abortion. We've also seen some of these employers, law firms and companies, being under scrutiny for, in particular, violating state law. Texas state law, for example, criminalizes the aiding and abetting of abortions. So I think these arguments will continue to get fleshed out. In the meantime, just last month, the Department of Health and Human Services initiated some rulemaking under HIPAA that would make it clear that health data and information cannot be used to investigate or prosecute those involved in the provision of reproductive health services. There's also an ERISA component to this that Holly's going to touch on.
You know, those of you who know me know I cannot resist an opportunity to inject ERISA into a discussion about pregnancy and all of that. So we just heard Texas has got this statute. Other states may have statutes that will cause employers concern if they want to, for example, pay for travel for their employees out of state to obtain abortions. So let's talk about ERISA. We all know the most famous thing about ERISA is preemption, Section 514. It is a tremendous section of law. It says that any and all state laws, insofar as they may now or hereafter relate to any employee benefit plan governed by ERISA, are preempted, right? So what is an employee benefit plan under ERISA? A plan, fund, or program established or maintained by an employer or by an employee organization or by both for the purpose of providing an enumerated benefit to a participant or beneficiary. So you write a plan, you're an employer, you say, here's our plan, our benefit plan, which pays for employees to travel outside. This is our plan, this is our program that provides a benefit to our beneficiaries, our employees. Potentially, the argument is state laws that are contrary to that are fully preempted by ERISA.
I think additionally, employers wishing to provide these benefits may also rely on the right to travel. Justice Kavanaugh referenced that in his concurrence in Dobbs, saying that states cannot prohibit residents from traveling in order to obtain an abortion. And so the extension of that would be that employers can provide benefits for that travel. There's also a 1975 Supreme Court case where the court held, Bigelow v. Virginia, the court held that a state cannot prohibit the advertisements of abortion, even if abortion is illegal in that state, if it is advertising for abortions that are legal where they are to be performed. So a lot of unknowns here. I think in the meantime, we do still see a lot of employers accepting the risk of violating state laws, whether it's because they think the risk is low or because they think that recruitment and retention or PR benefits outweigh those risks. So that's what we wanted to touch on. Holly, I don't know if you have anything else related to this point.
No, I was just a closing remark, which is we talked about consensus, we talked about places where there may be division. It seems like there are a few talismans of consensus at the federal level, which are, majority of states already have protections, and we already have existing statutes to hang federal protections on or increase them, like Title VII and the ADA. So those would be the things I would watch for. What's happening at the state level, and are there similar laws already federally to see what is coming down the road in the long run.
Good.
All right, thanks, Kate and Holly. We turn over to Sam and Rachel for the contract reform subject.
Rachel and I worked out a scheme here. I only get 7 minutes. So Rob,
Good luck with that.
this is another instantiation, whatever the word is, of Sam Estreicher as a fearless idealist dreamer. So here are a couple of ideas: employment law reform for the long haul. This is the 3-page paper. I'm actually quite terse for an academic. 6 areas that I think should be considered. Obviously, there's a lot of people have lots of ideas of changing Title VII, but I'm trying to think of things that there might be some bipartisan agreement on. One is, I think the EOC should be given resources to take on more individual cases, even if they don't have an impact on the law. Because I did a whole conference on this, people that are making under $70,000 a year. And I've got great employee-side lawyers who are members of my advisory board. I'm seeing them right now. But there isn't a bar for most of these people. And the EOC, I think, could play a role here in addition to pursuing systemic change. Now, they may need more resources, but this should be a focus of the EOC as well. So resources there, and I think, I know Zach Fassman disagrees with me on this point, but the 90-day period of time to file a suit from your right to sue letter is too short. These are people without lawyers. Most of them don't have our education, nowhere close to our education. And there is no bar out there. And this is one thing I think the EOC could do. Notice to these folks. Give them a list of the plaintiff lawyers that are out there that they might be willing to consult. I mean, because 90 days to get a lawyer is just unbelievable. And they lose their Title VII right. I think most employers concede this and would agree with me. Number 2, this is a little controversial. But I'm a firm believer, and I've written a ton on what the developments in employment arbitration, largely in support of them. By the way, what people said about this preemption article of mine, I'm against these preemption rulings because they penalize people who are union represented because they happen to have their collective bargaining agreement will not be interpreted in these cases. In any event, so on this point. Pre-employment arbitration clauses are a good thing. They can be a bad thing, and I'm afraid there are pigs among employers. There are pigs among unions. There are pigs among employees. And if you act like a pig, you deserve to be slaughtered. The problem is it has negative externalities for how the law develops. So anyway, on this point, class action waivers. I know employers love this, but I think it goes a step too far, and it's bringing down employment arbitration. What's good about employment arbitration is that the capitalists, in their own self-interest, are providing a low-cost forum for adjudicating these claims. Arbitrators are highly reluctant to grant summary judgment because, most of these cases are weak, but you get a hearing. Now, I know the dean of Cornell, despite the fact that Cornell ILR, I've told him 100 times, you cannot compare cases that have survived all the hurdles of employment litigation and get to a jury, the outcomes there against the outcomes in arbitration where people have a hearing and these are weak cases and they lose. I've told him this 100,000 times. He just doesn't hear me. I'm not using the right hearing aid with Dean Colvin. But I think this class action waiver goes a step too far, it undermines the whole institution. I know there have been a bunch of Supreme Court cases about it. It's going to require statutory change. And I know that employers are going to be reluctant to give this thing up, but if they want to have a viable employment arbitration system, and I think there's a public policy behind that. I just had this conversation with Solicitor Nanda. She said no. She doesn't like it. Just have post-dispute arbitration agreements. Fine. Employers are not going to pay for post-dispute arbitration agreements. Why not? Because if they don't think you have a lawyer, they're not going to settle. That is just, and we have data on this, on post-dispute arbitrations, virtually unheard of. It's unheard of in arbitration. It's always been unheard of. You always, at the end of the day, if you have a dispute and you know the guy's got a good lawyer, you got this fellow, you know, and you're a plaintiff, or you got Kate, you know, they know they're going to litigation. They don't want arbitration either, by the way. And so there isn't really a dynamic there for post-dispute arbitration. But I think there's something that can be done to get information to the Department of Labor about the nature of these cases. There are things that can be done so that it's not a completely a private process. All right, that's my second. I think that's the most controversial thing I'm going to say. Number three, oh, also, by the way, there should be an appellate capacity in arbitration. I know the Supreme Court had a ruling on this, and so it's going to need an amendment, but it should be an appellate capacity that is provided by these various arbitration organizations and is enforceable. We'd have to figure out the rules for it. I think some organizations do it. The Center for Public Resources does it. I would also have clear language that says if an employer is implementing a pre-dispute arbitration program, the employer pays for the arbitrator fees and the forum fees unless the claimant doesn't want that. Sometimes the claimant doesn't want that. That should be the cost of the process. I know there are arguments about how to interpret the AAA rules, but it seems to me it's going a step too far. Again, acting like a pig. And by the way, I don't eat pig. That's how I really respect pigs. You understand that? We in the Jewish race, or whatever you want to call us, we respect pigs. All right. Thirdly, I don't know if this is controversial or not, but I spoke to Craig about this. He supports it, I think, or maybe he'll tell you differently. Craig Lean. There are categories of workers that just are not going to get hired. Stand on your head, shove a ton of resources at the agencies, they're not going to get hired. Okay. How do I know? From experience. Do I have a super empirical study? I mean, it's revealed there in the hiring rates for these people. Unless you're getting paid to do this, you are not going to hire a ex-convict. That's getting paid, or the federal government says that is the cost of a federal contract. It'll happen there. Why, you ask? Because it's a risk. Now, they may hire them for certain jobs, but it's a risk. And why take on a risk? So you have these ban-the-box laws, which were, in my view, stupid laws, because they have an employment gap on the application. And by the way, the data, this actually is empirical work on this. They're not getting hired. Guess what? You leave out 8 years of a person's life in the CV, they're not going to get hired. So you lie. Then you find out they lied. Then you fire them. The law doesn't make any sense. I know that NELP supported it. Sometimes NELP is wrong. And there's another category. That's one category. Second category, people like me. Not entirely like me because I'm a genius, but people 55 and up in middle management positions. No one wants them. Now, I think there's a lot of unfairness in the labor market here. They should take a chance on these people. The employers get enormously risk averse here. I know it's violation of ADEA. All this stuff is a violation of this is violation of ADEA. No one wants these folks. Now, if they bring a big book of business, Morgan Lewis will take them. We're not talking about those folks. Even Elon Musk could get a job. But in general, no one wants these folks. They think they're not going to fare well under the lower salaries they get. They're no longer going to have this big office. They're no longer going to supervise people. You don't take a risk. It's hard to get rid of an employee. I know we're at will, but let me assure you, it's hard to get rid of an employee, and good for it. I tell the Europeans all they have is a boring chocolate cookie. They have employment legislation, but no damage recoveries. We did a whole article on this for North Carolina Law Review. 4 months back pay. I ask lawyers in Europe, what's the settlement range? They say, we don't believe in unjust discharge. Neither do we. But what if there's a disagreement? It's a very low settlement range. These are labor courts. We have jury trials, punitive damages. Wonderful plaintiff lawyers here. Go on and on. So, third category, people with obvious costly to accommodate disabilities. I know the statute says it's a multi-pronged analysis on the ADA. It depends on the size of the entity. We had a friend here who worked for a major company. He's a brilliant guy, by the way. He did 3 volumes on employment discrimination law. My grad student. He now wanted to be a litigator, had been a kind of counselor for the company. He knew every defense lawyer, every plaintiff lawyer in the city, couldn't get a job. No one's going to hire someone who's blind if you have to assume the cost of the reader. And you want to deal with that problem, provide for public provision of readers or other kinds of costly to accommodate. Instead, we got this law that says, pretend there's no problem. Well, guess what? They don't get hired. So these are 3 categories of workers I've talked about. They should be able to volunteer. Nothing compulsory about this. If there's compulsion, make that actionable. They should be able to volunteer for a special program, public program, where some employers are willing to take a risk on these folks. They will be protected by all the discrimination laws except at point of termination. They can be terminated after 1 year or 2 years, whatever the provision says. I think the EOC can do this. I've suggested it to them. They're sort of unwilling to do it. I've had very important academics tell me I'm advocating second-class citizenship. They can be fired without regard to external law at the end of that apprenticeship period. What is the idea? The idea is employment is an opportunity to get to know whether you can live with this circumstance. Now, it's not second-class citizens. Second-class citizens is when you can't get a job. That is second-class citizenry. This would be a voluntary program. And I think the EOC has authority, but if that's unclear, let's pass a statute. Another change, which I've written about, I'll send you the articles. I wrote it, published in Bloomberg, and then we published an article on it. What do you do about Harvey Weinstein? In general, there's no tolerance of harassers at least my experience in these big companies, no tolerance, unless the person is bringing a lot of business into the firm. He's a rainmaker. That is a problem. It's a serious problem. Harvey Weinstein was a serious problem, and there are many of these folks. It's hard to believe that these folks exist, but there are many, many of them. What do you do about them? I think the EOC also has authority, but if it's not clear, let's pass a statute, because I think everyone would agree with this. I think if a person appears more than once in a settlement agreement or a non-disclosure agreement in a case involving a sexual harassment or sexual assault claim, that name gets sent to the EEOC. Why are we doing this? Because there is no resolve in HR with these rainmakers. They have no backbone with these folks. And he's a striker, not here at Proscott. Look, I know there are exceptions to that statement, but in general, I am right. There is no backbone for these persons because they're bringing in a ton of business. Or like the Hatsitasi guy at NPR, you don't want to get rid of him. Because like a lot of people want to work for him or whatever. They're tolerated. So you send a letter to the EOC, and they maintain a confidential listing of these people. I think this will also stiffen the backbone of HR. And the EOC has the authority now in the current law to bring a commissioner's lawsuit. They should. Just saying that this is available will stiffen the resolve of HR. Now, are there going to be all kinds of issues? Is it discoverable? When is it discoverable? I would say it should be confidential until a public suit is filed. But there might be disagreements about it. And I think this could be something that could be done in the current law to deal with a real problem. Okay. I'm almost done. I know we're not going too far. I think that even though Farragut Ellis was beauty and music, because I'm a schizophrenic person because I have been practicing law while teaching law. It's schizophrenia. I'm a Jekyll and Hyde at the same time. But so Farragut Ellis is like music to employer ears, just like ERISA preemption was music. I mean, I think Roger would agree with this. Roger, are you here? Yes. We want preemption without substantive regulation. That's what the employer class wants, doesn't it? Roger, isn't that right? That's what OSHA did for us on employee welfare benefit plans. No regulation and preemption. She's found a way. She's also a former student, by the way, and an adopted child of NYU, Holly Weiss. She's found a way to use ERISA preemption for claimants. Fantastic. I mean, we got to give you a medal for that. Okay, so we love Farragher Ellis, but there's a problem with this failure to invoke local remedies. I know I don't sound like a management lawyer, because I'm not. I call things as I see them. There is a problem with the requirement to invoke internal remedies for victims of sexual harassment, sexual assault. It's like going too far. Now, I know the Supreme Court put it in there. This may take a statutory change, but it should not be a mitigating factor from your recovery. Now, I still think employers should be advised to have user-friendly procedures and all that. It'll look good in front of the jury, but it should not be an automatic bar to the case. So that may require Title VII change. And here's the last one. I have to give something to the employer class. I think the Fair Labor Standards Act should be amended to provide, if you're making $200,000 or more, exclusive of tips and bonus, you're exempt from the overtime provisions of the Fair Labor Standards Act. Now, I know everyone wants the FLSA, it's a good friend, but these people, generally speaking, can fend for themselves. And they should work overtime, in my view, because they're getting a ton of money. You say 200,000, nothing. Yeah, well, okay, let's make it 300,000. At some point, you know, I don't know, I'm an academic. These numbers are so far beyond my ken, you know. You know, I still remember when I got $300 a week for being a law clerk, and that was good money at the time. Okay, so something like this, maybe disagree on the 200,000, but the point is you're out of the FLSA overtime provisions and the minimum wage provisions. If you're being harassed because of your age, you should still be covered for that. If you're being harassed because you were once a partner and you're holding on to your client list, sorry. You're going to have to let go of it, and I'm sure the employer has gotten your consent. Anyway, those are my initiatives for the legislature and the EOC. Now here's Rachel Arno. I think I went more than 7 minutes. Rob, you should have stopped me. Okay.
All right.
Rachel Arno is now going to criticize the work of the restatement of employment law, which was also my baby. Go ahead.
Okay. You've met, I'll try not to go too hard on the restatement. Okay, so I'm going to shift to talking about employment law reform from a contracts perspective. And I know that contract is probably not what leaps to mind when you think about reform. You're probably thinking about the type of statutory proposals that everyone has been talking about, which in fact are going to limit what people can contract for. However, common law and courts have a role to play in employment law reform for the long haul, and are really the only path toward fixing this problem. Let's see if this works. Okay, so these are some choice terms from employment contract law jurisprudence, which you're probably familiar with as employment law attorneys. And what you can take away, I think, from this slide is that the law of employment contracts, of at-will relationships, is highly formalistic, very detached from real life. And in my opinion, it doesn't lead to particularly good results, and certainly not well-reasoned results. So you probably find it about as distasteful as this gentleman here. I certainly do as a contracts law professor. And so my project is to eliminate and tear down this poor version of employment contract law and forge a more coherent, hopefully modestly transformative reforming approach to the law of employment at will. And so that's a tall order. This is the roadmap. I want to talk just a bit about how we got into this mess. I want to sketch an idea for what in our paper we call, this is co-written with Rip Verkerke, a professor at University of Virginia, a hyper-relational version of employment contract law, and then a few minutes on implications. And I may run out of time, or you may need to take a phone call. So this is where, this is a thumbnail of where I'm going to wind up at the end. Okay. So in contrast to the former slide, this is what I think of, and admittedly, this is a factual depiction of employment at will relationships. It's what I think of as the features of that relationship that should be sort of part of or embraced by any viable theory of contract law or framework for contract law. And of course, the gulf couldn't be wider. I'm going to go back for just a second. So the central error in the current framework, as we point out in the paper, is this idea that employment is a unilateral contract. Now, you know, I don't know how far removed you are from the trauma of first-year contracts, but if you can remember, that's where you tell somebody, I'll give you $100 if you walk across a certain bridge a bit southeast of here, or, you know, ask them to find a lost pet or whatever. And I think it's pretty clear that employment relationships do not analogize well to this model of a discrete performance, or really anything else that falls within what we call in the paper the reward paradigm. You know, do X, I'll get you Y. You know, I'm not going to, this is all pre-ERISA, and to save time, I'm not going to go deep into this, but the origin of this approach is really interesting because it comes from pre-ERISA deferred benefits promises, going back to like the early 20th century, which actually did analogize more closely to the reward paradigm of unilateral contracts. It's like work here until X number of years and you'll get Y. The problem is, and you will all sort of remember the heyday of implied contract theory, or maybe if you don't remember it personally, you know it from the case law. You know, for a very sort of this was a short-lived but much maligned period of history in which courts decided to extend extend contract rights based on handbooks and policies and so on. Well, you know, how did they justify this move? They reached for what was at hand, which were these deferred benefits cases from the early 20th century, and of course, that was based on unilateral contract theory. And so, you know, whatever unilateral contract models are worth in the benefits context, they really don't work at all when you have an indefinite term relationship. But this approach essentially brought to the fore what we deal with now in contemporary cases involving changes of terms and so on, which is the idea that the entire relationship of employment at will is a unilateral contract. Okay, so that's the problem. I'll let the slide speak for itself, but the upshot is we don't have a contract framework for making decisions about, or reasoned decisions about what parties' rights and obligations are. You know, and this, of course, I'll just, you know, a pitch is, this is the foundation for everything. All of the statutory initiatives that we're talking about, all of the questions that we have been raising for this conference are built on this framework as sort of exceptions to this underlying approach to employment relationships. So that's my pitch really for why it's important. Okay, so what's the solution? You know, the problems of employment contract law we submit in this paper can be solved through actual contract law. And so here's a little bit, this is probably even worse history for you than the employment law history. But what the short version is that employment contract law is a little bit of like that lost race of humans that like didn't evolve. And that's because between the early 20th century and the deferred benefits cases that I mentioned, And, you know, the period of time in the 1980s when courts started to develop employment contract jurisprudence, you know, something close to a revolution in contract law happened, which was the drafting of the UCC, the second restatement of contracts, not talking about employment contracts, and the legal realist movement. And what happened was contract law embraced a variety of flexible concepts that were very much geared toward making contract law look more like life, which is the exact problem that we have with employment law. And, you know, of all places where we think maybe contract law should be more relational, more reflective of people's lived experiences, it would seem to be in the employment context. And so in an odd way, commercial law and the contract relationships of businesses and commercial actors is more sort of informal, if you will, than our employment law, which is an oddity. So here are the key concepts. If you, does anyone deal with commercial contracts and business contracts besides employment law? I know Sam does everything. I just don't know. So you know, so these are them, and I will also caveat that this is a very, I won't say it's an aspirational, but it's one view of existing contract law. And some of these concepts are contested, but you know, here are some basic ideas. One, a looser approach to contract formation, and specifically the rejection of unilateral, bilateral as distinct types of contracts. Two, a tolerance for indefiniteness. So recognizing intent to be bound, even though certain things like contract duration are unstated. A willingness to supply terms based on context, if terms are missing, or based on predetermined defaults, all of which are based on reasonableness, including reasonable duration, reasonable notice, and I'll return to some of these in a minute. Liberal contract interpretation principles, so the UCC, for instance, explicitly states that parties' agreements embrace more than just their formal express terms, include trade use, practices of the parties, and so on. The right to set terms and alter terms after the fact. So this is the allowance for discretion. Parties can do that, provided it's done in good faith, which is an overarching obligation that limits discretion, prevents interference with the opposing party's receipt of the benefits of the bargain, and by some definitions, also prohibits a variety of other behaviors, and most importantly, cannot be fully waived by the parties. So I think you can see how some of these concepts are going to map onto employment. This is essentially the slide, the bottom of the slide I had in the beginning. Real contract law, or sometimes I call it mainstream contract law in my writing, it would describe the entire relationship of employment as a binding bilateral contract consisting of reciprocal terms, the employer to pay to employ the worker, the employee to provide that labor, as well as any other express or salient terms, plus implied terms. So what implied terms are you wondering about? This is the one that employers are not going to like. And forgive me for forcing you to read a section of the Uniform Commercial Code. But the first is that contracts are valid for a reasonable time, although they may be terminated for any reason. And this is sort of one of the fascinating things to me, because the UCC embraces the idea that contracts are at will, but also requires that they endure for a reasonable time, and also that the losing party in a contract receive reasonable notice of termination. Back to this list. In addition to the implied background terms, you would also, if you were looking from a contract's perspective, imagine a more robust duty of good faith that goes both ways, employee to employer. Employees inevitably commit to using best efforts in their jobs. Employers not only agree to compensate, but they essentially agree to provide instruction, opportunities for promotion, and so forth. And most importantly, not to impede the worker in that developing process. And And yes, there's a whole lot more to the relationship that is within the employer's that both parties understand that the employer will determine. So setting day-to-day work terms and so forth, and that those will change. Contract law would view that as contractually conferred discretion, which has to be exercised in good faith by the employer. And here's where we go a bit off the rails. These approaches contemplate a limited ability to disclaim these baseline terms. And this would require, and I have a second paper in the works. I'm not going to talk about this right now because we're low on time, but we have a paper in development that reviews a lot of the justifications for revisiting the judicial approach of simply rubber stamping employer disclaimer languages. Okay, so to cut to the chase, I'm going to not talk about this. These are some of the justifications for doing that, for limiting disclaimers. These are the sort of the baseline terms that we are suggesting cannot be waived. And it largely goes to questions of advance notice as well as basic obligations of good faith. And here's just where I'll end. So what are the implications? So I think you can think about this framework as having potentially 3 sets of implications. Things that are brand new, things that justify existing law, and then things that extend from existing law. And so the new stuff is, the reasonable notice of termination, as I mentioned. The new material also consists of at least one judicial reversal. After all, this is a panel on reform. So a more limited view of employer disclaimer language. What you'll notice is that it also provides a coherent explanation for some law that has not, in the implied contract sphere, that has never really made sense. Why do we require advance notice of changes in handbook language? Notice I'm embracing approach that is in the restatement of employment law, Sam. I think that the notice rule is correct, but it's not been sufficiently theorized. This notice approach explains why employers have to provide that advance warning in changing their handbooks and personnel manuals. It also, interestingly, supports the minority view on promissory estoppel claims for new workers only, that they need to have a reasonable duration to start their employment. And then finally, I think that there would be some new good faith claims under this theory, particularly the claims where employees assert that they're fired for quote unquote doing their job well. So those are my comments. Thank you.
Thank you. We have about 5 minutes left. Let's turn it to Doug for some commentary. There's a lot to cover there, Doug. So.
Great. Well, thank you very much, Rachel and Sam. So I'm going to engage in some, I guess, what you would call speed dating here, because there is a lot to cover. I'll start with some comments on what Rachel has to say, just because it's most in your mind right now. And I think that I would commend to you the article, the draft article, when it appears. I guess we have it in the materials. It's a wonderful history of employment contract law. It happens to sort of follow the arc of my career in a way, having started as an employment lawyer in the mid-'80s, and I, as on the plaintiff side, if I could say. And I remember reading this Toussaint decision and thinking, my goodness, things are really going to change here. But I can tell you, just summarize that part of the article. It's Toussaint good from Rachel's perspective, Banky bad from Rachel's perspective, because that's the decision a little while later that said, actually we're going to rethink this idea of giving employees a cause of action based on the handbook. But so as wonderful as the article is as history, I think what it exposes is why traditional, and I agree with a lot of it. I mean, I think the idea of unilateral contract as being completely wrong is completely right. I think it's a bilateral contractual relationship. I talk all the time to employers who say, we talk about, well, I don't want a contract, I just want an offer letter. Well, what? I mean, no, I don't say it that way, but an offer letter you're establishing a contract, and I think it is bilateral contract. That said, it's too easy for employers to do what you described, which is to just put in the handbook or to put in the offer letter and to put in all sorts of places that no, this is meant to be an at-will relationship, and that's what we're going to have, and exactly what that means, written in a way that, as Denzel Washington said in Philadelphia, the average 7th grader could understand. And so, I'm in that group, and I finally found myself in the conclusion of lawyers or of observers who say, well, really the way that we need to deal with this is legislatively. Sorry to say that, but that's kind of where I come down to require. Because I think Rachel's next step after this, and I'm eagerly awaiting. This is the deconstruction article. I'm eagerly awaiting the sequel, season 2, the reconstruction article, because I am curious, but I think the next step is to train. In Rachel's view, I think is to enforce employer assurances of job security, to require reasonable duration, reasonable notice of termination. My next step would be different, and I would argue is how the kind of the arc of legal treatment of the employment relationship is bending, and that is in one of 3 ways. Very few employers will choose to go full Toussaint and draft a handbook without the disclaimers that provides promises of job security in exchange for the employee's promise to perform services. Still more employers will be forced by an employee union to provide those promises in a collectively bargained contract. But the largest group of employers will be bound only by, ultimately, they'll try to preserve, as I just said a minute ago, the at-will relationship in a written understanding. Everybody, can read it and understand it and sign up for it, of at-will employment, and so they're only going to be bound by legislation, and that legislation will supply the public policy society wants to see governing the employment relationship, the kinds of things that we want for ourselves, our parents, and our children, in terms of their employment relationship. And I think that's what's happened. Starting in this city, go outside, look at what the New York City Council has done. It's surpassed California in terms of protecting employee rights, and I think maybe in your terms, Rachel, in supplying contractual terms for employees generally. So I guess maybe I'll stop there. But I did finally see a citation, because this is what I was thinking about as I was reading the history part of this book called The Transformation of, 2 books, The Transformation of American Law, Mort Horwitz. I felt like this, you're taking us through the history of employment contract law was kind of at that level, was really quite impressive. So thank you for the article. Now, more speed dating quickly to Professor Estreicher. Not a good week to talk about increasing federal spending on anything, dude. So I'm saying
That's true. It's not a good week.
So I'm saying maybe, and as an alternative, and as a former state agency official in the Commonwealth of Massachusetts, look to state agency. I mean, so I don't disagree with you about state,
The fundamental problem is we have employees for whom there is not a bar. That's the problem.
No, that's right, exactly. And when I worked and helped run the state agency in Massachusetts, we saw ourselves, and I think these agencies have to see themselves, and the solicitor talked about the equity lens of viewing things. I mean, this is essentially like a legal services office for those lower wage employees, and that's an important way to look at it. And but too frequently will. So for one thing, there's a lot of states left that don't even have an agency, guys. I mean, if you just look at the Southeast and kind of go a little bit west from there, all they've got is the EEOC. So one thing to do would be to take the constituencies in those states and have an agency, at least at the state level. But another would be to look at the agencies as law enforcement agencies as opposed to just dispute resolution agencies. So that's one thing. We tend to advise on the arbitration stuff. Hard to do this in 15 seconds, but we do tend to advise clients to pay for the process. You know, the class action waiver issue. Just the most fascinating thing about that is the whole mass arbitration phenomenon. I've actually arbitrated one of those as an arbitrator. 1/1000th of the mass arbitration procedure, and it's I mean, talk about, you know, what you wish for coming back to bite you. That one's got a long history ahead of it. And I'll just I think that the on the Farragher and Ellerth piece, again, I'm sort of parochially Massachusetts based, but there's a case in Massachusetts called College Town that's been on the books for years that basically says that if it's a supervisor, it's strict liability. And that, so you got no Farragher.
I'm
and Ellerth.
referring to Title VII.
Yeah, no, I understand.
And the
but-
state law could be different.
But we're, you know, if you're on the, I mean, there's a lot of plaintiffs lawyers in the room, you're often filing only state claims in states where, you know, and there's something, I think, there are many things that the you know, the federal courts can learn from the state courts, and the federal agency can learn from the state
Right.
agencies.
All right, well, join me in thanking the great panelists.
Good job.